This conference will now be recorded.
So let's get started. Let's move over to, I think you guys can see the how to stay out of real estate jail screen. It's showing up on mine that you can. Just a real quick recap of what the top 10 NCREC complaints were: the disclosure of material facts, mismanagement of trust accounts, disputed deposits, charges against security deposits, short sales, drafting legal documents, disputes regarding contract acceptance, conflicts of interest, lack of communication, and loan fraud. Those are the top 10 things that get people in trouble with the Real Estate Commission. And those are the top 10 things that they have hearings about at the Real Estate Commission. And we did record that session last time, and I did send it out. So you can watch that one in full. So the next thing that we deal with is the North Carolina Realtor Association legal hotline. And this is basically a free service through North Carolina Association of Realtors, and our NCAR dues pay for us to have access to this free legal hotline. And these attorneys that represent this legal hotline actually specialize in real estate, and they work in conjunction with the North Carolina Real Estate Commission. They are not part of the North Carolina Real Estate Commission, and they are not attorneys for the North Carolina Real Estate Commission. They're not representing you when you call them, but they are a great window into seeing what the questions are and what end up on their desk. And so it's always good to sort of be able to look behind that curtain and get a step ahead of it. Now, in 2022, there were 7,000 calls to the legal hotline, and they've broken it into percentages here. 36% of the calls were just basic form questions, 14% miscellaneous, 11% about disclosure, landlord tenant, license law, contracts, commissions, code of ethics, advertising, agency, fair housing, property management, and then local board. Why aren't you in our meeting, Mr. Roger?
Well,
Roger's here. He's just not joining our meeting today.
I've got a doctor's appointment.
Oh, well, you're excused then. He has a doctor's note, so he's
Cassie
okay.
has some good stuff to talk to you about, though, about somebody's up my butt.
Uh-oh, okay.
You'll
I have to ask her about that. Okay, so the top 10 that have landed on the North Carolina Legal Hotlines desk. Question number 1 that they get the most: is my client under contract? What do you notice here? That there is some overlap here with the North Carolina Real Estate Commission, where the agents find themselves in front of the Real Estate Commission. All right. So again, it's very important to understand when your client is under contract and when they're not. Form 2T becomes effective and binding on the date that the last one of buyer and seller has signed or initialed this offer, or the final counteroffer, if any. And number 2, such signing or initialing is communicated to the party that made the offer or counteroffer, as the case may be. The buyer and seller are not under contract until both of those elements are satisfied. It's worth noting, as a related matter, that the North Carolina Realtor Association has written several Q&As this year, and you can go to their site, ncrealtor.org, and you can actually read their Q&As, and they have one come out every week, and they are very relevant Q&As because it comes from real estate agents in a specific situation that they have had that week or that month that they're asking the legal hotline about. So it's always good to visit their site. Question number 2, offer to purchase and contract. The seller failed to disclose a defect related to the property. Can my client terminate and get their due diligence fee back? Again, material facts and disclosure, this is something that we just saw, that this is one of the top 10 things that agents find themselves in front of the real estate commission in a hearing for. So this is another thing that's extremely important. A seller ordinarily is not required to disclose facts about their property. However, a seller must disclose material facts when such facts are only known to the seller and not within the diligent attention, observation, and judgment of the buyer. In other words, if there is a material latent defect on the property only known to the seller, and the buyer cannot reasonably discover this defect through doing reasonable diligence, then the seller has a mandatory duty to disclose. As you can see, this puts us in a bind because somebody has to determine what or could a buyer have reasonably discovered this through reasonable due diligence. All right, because that's not necessarily something that we're qualified to determine. And that's why it's always good to err on the side of caution. So when we tell a seller that they don't have to disclose anything, but they can't lie, so they can check no representations on everything. If they know that the upstairs window is broken and they know that there is a leak under the sink, all right, they can still check no representations on the RPODs and they're still in compliance because they don't have to disclose it, and a reasonably prudent agent and a reasonably prudent buyer in the process of doing their reasonable due diligence would discover a broken window and a leak under the sink, because it's very common for people to be able to see these with their own eyes because it's obvious. All you have to do is look under the sink, and all you have to do is look at the window, and those are very reasonable. However, if there is something very difficult to find that is not obvious when you go through and take a reasonable look at something, for example, let's say that the seller, their basement floods, all right, and they know that they have a problem with their basement flooding after a very heavy rain. And there has not been a heavy rain, and they have a buyer come through and the buyer makes an offer, and the seller has not disclosed that the basement floods significantly during a heavy rain. And every time we walk through, we see no evidence of flooding, and they have not marked on the residential property disclosure that it floods, and there's no water in the basement. And let's say they've waterproofed the walls so you don't see the stains on the walls. A reasonably prudent agent and their buyer are not going to be able to necessarily know that a basement floods in heavy rains. All right. So after we close, there's a heavy rain and the basement floods, and the new owner, which was the previous buyer at the time, calls a basement waterproofing company, and they come out and they say, oh yeah, this seller, this is like the fifth time this has happened. We have come out here multiple times and had to clean out their basement. All right, well, what's probably just happened there is that the seller can very likely be held civilly liable for not disclosing a latent defect on their home. All right. So this is something that a lot of times it's splitting hairs, and it's not something that we're going to be qualified to be able to tell the buyer or the seller, yes, you're going to be held civilly liable for not telling them this. Nor can we tell the buyer that seller is going to be civilly liable. You can take them to court and you're going to win. When things like this happen, this is something that you need to refer your buyer and your seller to an attorney, because these are the facts. This is what the Real Estate Commission and the legal hotline want us to know about this, and that is that a seller is not required to disclose anything. However, if there is a hidden defect that they know about and they are deliberately keeping it from the buyer, and there's no way for the buyer to know it from doing their inspections and doing reasonable due diligence, then it is possible that that seller could be held civilly liable, and they would have to not only give the due diligence money back, but there's a chance, especially if it's after closing, that the previous seller could be sued for thousands of dollars. So this is a very important question, and you need to understand how to answer the seller when they are filling out their RPODs. All right. So if you tell them you don't have to disclose anything, then you need to make sure that they read the part that says that they cannot hide defects and try to hide it so that nobody can discover it. They also can't lie. So when the Real Estate Commission and the legal hotline tell you that the seller does not have to disclose something, there's a difference in not disclosing and lying. So let's say that we go back to just the leak under the sink or the basement flooding. All right. So if the buyer agent goes to the listing agent and says, will you ask your seller if they know of any leaks? And the seller says, no, nothing's leaking. Then they could be in trouble because they didn't have to disclose it. But if you are asked, then you have to tell the truth or you can be in trouble. Now, the difference here is while the seller does not have to disclose anything, the real estate agent has to disclose every material fact. So when you're listing that home and the seller says, I have a leak under my sink and the upstairs window is broken, but I'm not going to be disclosing that to buyers because I choose not to, and I'm going to check no representations on my RPODs, then you have to say to that seller in that moment, that's great, and you have a legal right to do that. However, do what? Who was talking? I have a question. Okay, I must have just been hearing somebody's microphone not off. You have to tell that seller, you have to say, look, I am required by law to disclose all material facts. So you don't have to disclose that, but I do. If I become aware of any material fact, I have to disclose it to the other side. I can advocate for you as long as you are asking me to follow legal directives, and it would not be legal for me with a license to not disclose things that I know. So you need to make sure that you understand what your role is and you understand what the seller's role is. And then you need to understand what's over our head and above our pay grade and when to send them to an attorney. So as it says, if a buyer goes under contract and it is later revealed that the seller failed to disclose a mandatory material fact or made a misrepresentation that the buyer reasonably relied upon, then the buyer could have several legal claims. The claims would vary from case to case, but if successful, the buyer could be entitled to damages. Such damages could be the amount necessary to place the buyer back in the same position they would have been had the offer not been made in the first place. That amount would at least include the due diligence fee. Some claims available to the buyer could award substantially more damages, plus an award of the attorney fees. So that is a really important part of what comes to the legal hotline because there is a big misunderstanding about this part. And as I mentioned last time, if you're representing the buyer and you get a copy of that home inspection and the buyer says, I don't want you to share that home inspection with the seller, you as the buyer agent are required to tell the listing agent the material facts. Now, what are material facts? Something that could impact whether a buyer makes an offer on a property or how much their offer would be. It doesn't mean that you tell them little things, but again, there's not a set list of what you have to say and what you don't have to say. But if you see that there is an active termite infestation and you see that the radon is 50 and you see that there is flooding in the basement, and you see that there is a structural defect in that home inspection, those are significant and impactful. And even if your buyer tells you not to share that home inspection, you can't share the physical home inspection paper necessarily, but you have to tell the listing agent about the material facts. And you have to tell your buyer, look, I'm not going to share this piece of paper with them because this report is what you paid for, but I'm required to share with all parties, regardless of who I represent, if there is a material fact. And these are impactful, significant things that must be shared. So I do have to tell the listing agent this. So keep all that in mind. Number 3, offer to purchase and contract. Is blank a fixture that must convey? Again, this is another big question that the legal hotline gets. So there are 2 categories of fixtures that you're going to see on the offer to purchase. The first is found in paragraph 2A, which states that all existing fixtures are included in the sale unless they have excluded them in paragraphs 2D or 2E. The term fixture in this paragraph is not defined and is controlled by state law. North Carolina uses the total circumstances test to determine whether an attachment is a fixture and therefore goes with the property. And what the test does is it looks at 4 factors. Number 1, what was the intent of the person installing the attachment? Number 2, the permanent or temporary nature of the attachment. Number 3, the way the property was adapted to accommodate the attachment. And number 4, the relationship of the person installing the attachment. The second category of fixtures is located in 2B, which contains a specific list. Some of the items in this paragraph are personal property, like the garage door opener. Other items easily satisfy the total circumstances test. And what paragraph 2B does is it makes sure that the bulleted items convey by agreement, giving buyers and sellers more certainty as about what is and what is not included in the sale. So you need to make sure you read over those, 2D, 2E, and that you look up the total circumstances test and apply those. Also, if you put something in MLS that says the formal dining room chandelier does not convey, and that's in MLS, and that's on your listing agreement, when you got everything signed with your seller, and you've got it on the listing agreement that it doesn't convey, guess what? It still conveys if you don't also put it on the offer to purchase. All right, so there's a 3-part thing here that you have to remember. Number 1, when the seller tells you it doesn't convey, you put it on the listing agreement. Number 2, when they tell you it doesn't convey, you put it in MLS. Number 3, you better make sure that you discuss it with the buyer when you guys are negotiating an offer, and that it is stricken through on the offer to purchase that chandelier does not convey. Because if you don't do that 3rd part, then what's on the offer to purchase and contract trumps what is in MLS. So you have not closed the circle if it is not also on the offer to purchase. The next question, how do I comply with the clear cooperation policy? This is a big question that the legal hotline gets. In 2019, the National Association of Realtors adopted a new and mandatory rule to be implemented by all MLSs called the Clear Cooperation Policy. The policy requires that every participant make a listing available to all brokers, and you have to do it within 1 business day of public marketing. So that means once you have a listing, and once you put that listing somewhere that the public can see it, whether it's that you put a sign in the yard that the public can drive by and know that this property is for sale, whether you put it on your own personal website where the public can look on that website and see it, if you post it on Facebook where the public can see that it is for sale, Once you put that listing in a place where the public can see it and know that it's for sale, then you immediately have one business day to get that into MLS so that all the other realtors can show it as well. You can't market a property and try to keep the buyers only calling you. You can't try to corner the market with your listings and double side everything so that you make more money. Because while that's what might be best for you, that is not necessarily best for your seller. Because normally the seller is going to have a better opportunity to make more money on their property if multiple people are interested in it and people have a sense of urgency with needing to move forward on it, and they feel like they need to make a good offer to shut out the other person that's interested. And so that's why they came up with this policy, because agents were doing what was best for them instead of necessarily what could have been best for their client. And that's what the clear cooperation policy is. So what people see is an agent will post, I have a new listing, and the agent will try to wait 3 or 4 days before they put it in MLS, hoping they get those calls. And what happens is, if you are an agent and you see that it's posted on Facebook, or you see the sign in the yard and you go into MLS because you have a buyer interested in that, or your buyer calls and says, hey, I drove by this house at 123 Smith Street and there's a sign in the yard, but I don't see it online. You go into MLS and you look and you're like, it's not there. Well, you know it has to be in MLS within 24 hours, or that listing agent is in violation of the clear cooperation policy. And it's very important that you understand this as well. You can't get a head start on the other agents. You've got one day to get it done. Question 5, is blank a material fact that I must disclose? In general, a material fact is any fact that is important or relevant to the transaction. Because that is such a broad definition, the Real Estate Commission has provided some guidelines regarding what facts are generally considered to be material. Those guidelines state that the following are usually considered material. Number 1, a fact about the property itself, such as a significant property defect or abnormality. For example, a malfunctioning heating system, a leaking roof, or some sort of drainage problem with the house or the property. Number 2, facts that relate directly to the property, such as maybe a proposed zoning change, or does it have restrictive covenants? Or are there nearby road projects undergoing? That's your second one. The third is facts that relate to a party's ability to complete the transaction. On the buyer's side, if they have to sell their home, or if they have not been pre-qualified yet. On the seller side, if they are in foreclosure or they have to do a short sale, those things affect whether the buyer or the seller can actually go through with the transaction and meet the expectations of the other side. Because a buyer who's got a contract on a home expects to be able to close on it, and a seller who has gone under contract with a buyer expects that that buyer is qualified to buy it. So those things are material facts about the party's ability to complete the transaction. And then number 4, facts that are known to be of special importance. For example, if I'm your buyer and I tell you that I want to have goats, that I want to buy a property where I can have goats. I love my goats. They're the most important thing in the world to me. Don't even consider showing me a property where I can't have my goats. And you find them a property and it's got a fenced in backyard and it's on 2 acres and it's the perfect place for the goats, but you don't look at the restrictions, and the restrictions say no goats, or no farm animals, or no animals of any kind, or only domestic cats and dogs are allowed, then you have not disclosed a material fact because that party has told you that they have something specific that is special, is of special importance to them. And therefore, it becomes a material fact because it is directly related to something they have told you is important to them in the property that they buy. And those are what encompasses material facts that must be disclosed. Question 6, this is about landlord-tenant. If a listed property has a tenant, is the lease binding on the buyer? Generally speaking, yes. If you list a property for Henry and Henry says, I don't live here, this is a rental property I have, and Sam is living in that rental property and they just signed a 6-month lease with me, then when you put this property on the market, you have to tell interested buyers that that tenant is going to be in that house for 6 months. So even though you close in 30 days, that does not mean that new buyer gets to move in. They have to honor the lease that has been signed. And so that's very important. Next question, number 7. I received a letter of inquiry from the Real Estate Commission and I'm freaking out. Can you help? So basically, yes, they're telling you that you can call them to talk to them about this. They want to make sure that you know that they are not your lawyer. They can give you general guidance on questions of legal importance, but they cannot give you specific advice on the hotline. But the guidance that they can give you is going to put you in a situation that you feel like that you can get a plan of action together. Specifically, if you're being sued, you want to look at your E&O insurance and make sure that you're following the requirements of your E&O insurance. And E&O insurance, has a deductible, and I think ours is $2,500 maybe. So if it's going to be something that's going to only cost you $300, $400, $500, $1,000, $1,500, you wouldn't use your E&O because you're going to end up paying $2,500 out of pocket just to use the E&O. The E&O is usually used for something big, some sort of big lawsuit that is going to be more expensive than $2,500. Question 8, can an agent bind their client to a contract? And basically the law of agency in North Carolina provides that a principal, the client, will be bound by a contract made by his or her agent if the agent acts within the scope of his or her actual authority. In North Carolina, absent special authority, a real estate agent does not have the power to bind their client to a contract to sell their home on the standard listing agreement. And absent evidence that the client has executed a power of attorney, the agent will not have authority to bind their principal. So don't go signing things for your client because you don't have the legal authority to bind them to a contract. And you're going to get in trouble if you sign things for them. As to whether an agent has apparent authority to bind their principal to a contract for the property, apparent authority has been defined by the courts as authority which the principal has held the agent out as possessing or which he has permitted the agent to represent that he possesses. So if your seller or your buyer gives you legal authority to sign for them or represent them, and it's in writing and it's been done legally, then yes, you can. But unless you have gone and done something different, you don't have that authority. The way it sits now, even though you are their listing agent or you are their buyer agent, neither one of those exclusive buyer agency agreements or exclusive right to sell listing agreements says that you have the authority to bind them. All right. You're advocating for them, but you're not them. Question 9, can I share my commission with my client? Yes. If you want to give a rebate to your buyer or your seller, you can because they are a party to the transaction. All right. So if you have a buyer and you guys are closing and you want to give them $500 of your commission at closing for moving costs and the lender says it's okay, Because they are a party to the contract, you can share your commission with them. You cannot share your commission to people that are not a party to the contract. So the answer is yes. The real estate commission takes the position that brokers may rebate or pay a portion of their brokerage fees to buyers and sellers who purchase or list real estate through the broker, because a real estate license is not required of people who list for sale real estate which they own, or who purchase real estate for their own account. Agents should have the consent of the principal. For example, if you're acting as a seller, subagent, or dual agent and you want to share a commission with the buyer, then make sure that you obtain their permission in writing. You also make sure that you are disclosing this to the lender, because it could disqualify your buyer or the buyer from obtaining the loan. And then you want to assure that the payment appears on the settlement statement, because if not, then you're committing fraud. And number 10, one of my agents would like to solicit a company's future business. Would there be a problem with the agent dropping off some marketing material for the owner's review and saying that he wants to be considered for company's future business? I found this interesting. Because it did not go down the path I thought it was going to go down. It says Article 16 of the Realtor Code of Ethics prohibits realtors from taking any action inconsistent with exclusive brokerage relationship agreements that other realtors have with clients. There are 20 standards of practice related to Article 16, and standards of practice are applications of ethical principles to specific conduct in specific circumstances as related to the Articles of Code. Now, standards of practice 16.3 and 16.6 are the most applicable to this. And when you read those together, they do draw a distinction between two different types of solicitation by the agent. Number one, the solicitation of a future listing agreement on a property that is currently listed with another realtor. Or number two, the solicitation of a listing agreement on property that the owner or future owner does not currently have listed. As illustrated by Standard of Practice 16.6, the first type of solicitation may be unethical unless the owner initiated that contact. But on the other hand, the second type of solicitation is specifically permitted under Standard of Practice 16.3, which says that Article 16 does not preclude realtors from contacting the client of another broker for the purpose of offering the same type of service for property not subject to other brokers' exclusive agreements. What does that mean? That means that if Cheryl has Sam's property listed at 123 Smith Street, all right, and I heard from my friend at church that Sam is going to be building a new subdivision over in Hickory in June, then just because Sam is Cheryl's client on this listing at 123 Smith Street, I can reach out to Sam and I can say, I heard that you're going to be starting a new subdivision in June, and I wanted to drop off some material because we have a new construction division, and I feel like I would be a great agent to represent you on that. Now, I think, to me, that's a very slippery slope, but it is, as long as you can prove it in writing with the date and time stamps and what it is you're saying. Now, when you have that conversation with Sam, you can't say, now, I also know that you have the house on 123 Smith Street listed with Cheryl. How is she doing a good job for you? Because I sure wouldn't mind if you're going to be working with me in June. Why don't we just go ahead and as soon as that listing expires with Cheryl, I want you to list it with me. Let's go ahead and put a plan of action together for that. You're in violation. However, if Sam calls you and says, I'm not happy with Cheryl. She's not doing a good job for me. I want to talk to you about listing this as soon as our listing expires, or I want to find a way to get out of this listing agreement with Cheryl. You can have that conversation. But if you call someone else's client and they currently have a listing agreement with them, you cannot talk about that property. Your discussion has to be about something that's not listed, about something in the future that they may be doing. And it cannot be anything about what they currently have an agreement with that agent to do in that moment. All right. Those are the 10. Any questions about any of that?
Yeah, I've got a question about number 4,
Okay. Let me go
um,
back to it.
about the marketing and the listing time frame you have in which to put the property as information in the MLS.
Mhm.
Let's say that I've got a client, a seller client, and that his property, we've got it listed already, but we let it expire because we're not getting much traffic on it.
Mhm.
It expires. And for some reason, we cannot get together, whether it be by email, by in person, to renew that contract or either rewrite the whole listing agreement. But let's say that he has my sign in his yard. Can that sign stay there or must he take that sign down?
You cannot have a sign in the yard if you don't have something in writing giving you permission to have it there. So when that listing agreement expired, you're in violation to leave that sign in the yard unless you have something from him, like a text
Mm-hmm.
that says, I can meet with you Monday to get everything renewed in writing. Then you're okay. But no,
What
you can't just float.
What if that keeps dragging out to where he can't meet me? He's not technologically inclined to, be able to get into his email, and this keeps dragging out. Yet that sign is still in the yard.
Well, you need to have a text or an email or something in writing that gives you permission to keep that sign in the yard until you can meet, or you're in violation.
Okay, simple enough.
Yep.
Thank you.
Uh-huh. Anybody else? You guys are smarty pantses. Nothing else? Nobody? Well, that's good fuel to keep on the brain. These are last week and this week are things to focus on, because those are the main things that people are getting in trouble for in this day and age. So now you know some ways to avoid it. And I think, Amanda, did you raise your hand?
Yeah, I did. Quick question. Are you going to send these to us emails so that we can review them? I missed the first couple, and this is all good information
Yes,
to
ma'am, I am.
do. It's like,
Yeah. 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 And you need to, review it and marinate on it. And then if you have any questions, you can reach out to me. But I've recorded this and it does show the PowerPoint within the recording. And I'm going to be sending this out to everybody. So if you guys have any questions, feel free to reach out to me. And I appreciate you guys coming. And I'll see you next Wednesday. And if anything comes up in the meantime, just reach out to me.
thank you so much.
All right, thanks,
All
Teresa.
right.
Thank you.